Hi, y'all, and welcome to tonight's live stream. We are 2, maybe 3 days away from opening statements in Donna Adelson's trial. Tomorrow, jury selection begins in what is going to be one of the most unhinged, wild trials of all of 2025. Today, just to give you a little preview of what's coming, the judge held an emergency hearing where not one, but two daughters of Donna Adelson are creating major drama, one refusing to testify for her, and the other actively planning to testify against her. Now, I can hear you saying, wait, what? Donna Adelson only has one daughter, Lee. We all know it's Wendi. Well, apparently, she also now has a jail daughter, and it's her jail daughter who is now saying she is going to testify against Donna Adelson. We will get into all of this tonight. Now, don't forget to turn on your notifications. We are going to be, for the first time ever in the history of this channel, going to be going live during the trial. I'll be doing gavel to gavel live coverage of the trial live stream. So I've never done it before. I'd love to have you come and watch the trial with me. We can hang out, get your popcorn. We are going to be talking about what is going on, and I'll be breaking it down, doing legal analysis throughout the day, talking about what's going on and what's happening. Now, there are, like I said, two last-minute motions that were filed and that relate to daughters of Donna Adelson, one a jail daughter and the other, of course, Wendi. The first motion was filed by Donna's team, and they are trying to block testimony by a woman who claimed she was so close to Donna in jail that Donna began to call her her jail daughter. But now that daughter, that jail daughter, has made a deal where, according to the brief filed by his lawyers, this woman got a sweet probation deal for agreeing to testify with some brand new allegations against Donna Adelson. And the brand new allegations involve Donna trying to persuade people to testify falsely on her behalf, hopes she could get out of what was going to happen in the trial. So I want to start tonight with Wendi and what Wendi has done in the emergency hearing, because that's the only part we heard during the emergency hearing, but we got some important intel on the other through a brief that was filed. We'll cover it all tonight. Special shout out to our first 5 in tonight's chat: Desert Rose, Peeps, Mildred, Just Mildred, Marion P, and Oklahoma GG. Appreciate all of you being there. Don't forget that this month is Make a Will Month, and you need a will. Unless you have purchased a lifetime supply of cat food and dog food for all of your pets, unless you have absolutely no one related to you, you need a will. It's just a practical thing. And I used LegalZoom to make a will for my dad. So what I know is that a lot of you have clicked on the link that's in the description, but not very many of you have made your will yet. Don't forget. Right now, this month, it's 15% off. It is an affiliate link. If you click on it, they will pay me some amount. So please use the affiliate link if you're going to make a will. And I strongly recommend you need a will. As we go into this, would you hit the like button? That wakes YouTube up. And if you would please subscribe to the channel, we would love to have you back for more. All right, so let's take a look. I want to focus on Wendi Adelson first, Donna's actual real daughter. Now, Wendi is already at the center of this case. She hasn't been charged in any way, but she was the woman married to Dan Markel. He's the one who was murdered. Now, according to the prosecution, Donna Adelson, working with her son Charlie, hired through Charlie's girlfriend 2 hitmen to go up and kill Dan Markel. They killed Dan Markel as he was pulling into his driveway, his garage in the driveway. And why? The prosecutors say it's all because of what Donna Adelson wanted. She was upset with Dan Markel. He had gotten divorced from Wendi, and now he was filing a motion to try to keep Donna from seeing her grandchildren, trying to prevent her from having unsupervised visitation with them. And he also was blocking the kids from moving to Miami, where Donna lived. Shortly after Dan Markel was killed, that's exactly what happened. Wendi and the kids moved down to Miami and, in fact, moved in with Donna and her husband, Harvey, for a time. So at this stage, Charlie's girlfriend was convicted. It started really, the two hitmen were convicted. First one pled guilty, and then one actually was convicted in a trial. And then the girlfriend was convicted in a second trial. And then Charlie Adelson was convicted. And now we have moved all the way up the ladder to Donna Adelson. According to the prosecution, it was her idea. It was all her stirring the pot and insisting that this happened. Charlie was convicted on November 6th of 2023. And just 1 week later, November 13th, Donna herself was arrested as she was trying to board a one-way flight to Vietnam. Now, Wendi has been subpoenaed by the prosecution and the defense. But Wendi's lawyer filed a new motion to quash the subpoena from Donna Adelson. It's a legal word, quash, meaning it's kind of like the word squash, like to squash, to make it, but it doesn't have an S. And it means they want the court, Wendi's lawyer wants the court to say, I'm not going to enforce this subpoena. I'm not going to force you to testify on your mother's behalf. Now, Wendi's willing to testify for the state, but what she's not willing to do is testify for Donna. Now, we'll talk about why, what the reason for that is, what the legal reason for that is, and we're going to talk about why Wendi might be refusing. So first, I want to put up the motion that Wendi filed, and I'm going to read just a couple of paragraphs out of it and then show you some of the law kind of behind this, and we'll talk through it. It will be easy to understand, I promise. Okay, so non-party Wendi J. Adelson is the daughter of defendant Donna Adelson and is expected to be one of the first witnesses called by the state in Donna Adelson's trial. That's interesting news. It's also true that she was one of the first witnesses called in Charlie's trial. Both the state and the defendant issued trial subpoenas to Wendi Adelson. By law, the state subpoena confers immunity on Wendi Adelson, but the defendant's subpoena does not. We'll talk about what that means. Don't worry. Accordingly, Wendi Adelson respectfully moves for permission to place a statement on the record regarding the state of Florida's trial subpoena, the state subpoena, and to quash the trial subpoena issued by defendant Donna S. Adelson. In the Madbanawa trial, now Katie Madbanawa was the girlfriend of Charlie. She's the one the state says hired the two hitmen at Charlie's request. In the Madbanawa trial, both the state and the defendant subpoenaed Wendi Adelson to testify. In response, Wendi Adelson filed a motion like the instant motion to place a statement on the record and to quash the defense subpoena on May 13th. The state subpoena affords Wendi Adelson use and derivative use immunity for her testimony in an instance where she would otherwise invoke her Fifth Amendment rights, while the defense subpoena provides no such protections. In the Madbanawa trial, the court quashed the defense subpoena and granted Wendi Adelson's attorney an opportunity to place a statement on the record. Right, let me, now, so you may be wondering, what are all these different kinds of immunities? Let me pull that out. I came up with this new format. I've been practicing trying to figure out how exactly we'll do the court trial, the format I'm thinking of using. But I need to say, thank you, Annie K., who has been a member for 18 months, which is forever. Thank you very much. I appreciate that. And Crazy Mom RN is a new member. Thank you very much. I appreciate your being a new member. Tear, oh, thank you for the compliment. I appreciate it. And we'll stop there. I'll get to the others in just a minute. All right, so now you may be wondering, okay, what is this immunity? What are they talking about? So I did a little chart for you that I thought would help explain it. All right, so this is the little chart I did about what these different kinds of immunities would be. If Wendi is subpoenaed by the state, then she can have use immunity and derivative immunity. That's by a statute. It's pretty regular. Every state has it, as far as I know. Florida has it. So what's use immunity? That means the state cannot use the actual testimony of Wendi Adelson against her. So, for example, if they then charge Wendi and she's in trial, they can't say, isn't it true that in Charlie's trial or in your mother Donna's trial, you said blah, blah, blah. And to give you an example, kind of real world example, let's say somebody said, is charged with bribing a councilman, and they say, I Venmoed Councilman Smith $5,000 so he would grant my zoning request. Now that would be testifying to actually committing a crime. And if the person has use immunity, then when they're charged, it can't be used against them. You can't say, didn't you say this? The state is allowed to offer that kind of immunity, but the defense is not allowed to offer that kind of immunity. The state is a state actor. They're in charge, basically, of the prosecution. The defense is not, and they don't have the power to give somebody immunity. Then there's derivative immunity. So that's where the state can't use evidence that gets derived from the testimony. So in other words, they can't say, oh, you mentioned this Venmo that you used to pay the councilman the bribe. Let's go out and get that Venmo account. We'll see the $5,000 on there that went to Councilman Smith, and then we can explain it all to the jury about how this payment was made. If the only way that the state is gathering this information is because it derived it from what the testimony was, they aren't allowed to do that. That's an immunity too. The government has to actually show that the evidence came from an independent source, not straight from what whoever the witness was said, but from an independent source. They had to have gotten it some other way. Now, what Wendi doesn't have, what she would love to have, is transactional immunity. That's where the state says, you know what, we're just letting you off on this entirely. You will not be found guilty of this. We're not going to even prosecute you for this whole transaction or this whole conduct that you've done. We're not even going to do that. So just come and testify freely. But that didn't happen here. That's not being offered by the state to Wendi. So, and to take our bribe example, let's say they said to the person who had Venmoed Councilman Smith $5,000, they said, you know, just come testify. We're not going to prosecute you. It's not you we want, it's Councilman Smith. So, okay, there's a little law lesson for the day. So we'll just count it as that. All right, so so let's take a look then at why let's go back to the motion and take a look at what the court ruled and why. Let's go back. So, and this is Wendi's motion, remember? And Wendi talks about the fact that in Katie McBanawa's trial, she was not allowed to subpoena Wendi, and the state was. She appealed. That was one of the grounds she appealed on. But she lost on that ground. They refused to do it. And here's what they said when they denied Katie McBanawa's appeal. They said, look, she gets cross-examination. So it's not like she doesn't get to ask the witness anything at all. Instead, what you've got is the examination straight from the state and then cross-examination on those exact topics. Now, what Donna would like, what Katie would have liked, is to be able to ask about other topics too, not just the ones that the state asked about. But the court said, no, we're not going to extend it that far. And they said, when the Fifth Amendment guarantee collides with the Sixth Amendment in circumstances such as these, the Sixth Amendment right must yield, because to require one to incriminate himself in order to afford help to another would be both unwise and unrealistic. So again, wait, what? What are they talking about? I did a little graphic for you here. And we're just going to look at the main parts right here. What they're saying, what the court is saying is, you've got one constitutional right that belongs to Wendi, and you've got another constitutional right that belongs to Donna, and are colliding. Wendi has, under the Fifth Amendment, the right not to be compelled in any criminal case to be a witness against herself. She has that right under the Constitution. Donna has the right under the Sixth Amendment to be confronted with the witnesses against her, but more importantly, to have compulsory process for obtaining witnesses in his favor. In other words, Donna has the right to have the court make people who have important information for her come to trial, and the court's not doing it. But what the appeal said was, look, you've got a balance here. You've got the right not to incriminate herself against the right to have witnesses come. We're going to go on the side of the Fifth Amendment. We're going to go on the side of Wendi's right over, in this case, Donna's right, or in Katie Mabanoa's case, Katie's right. So, Wendi said, look, here's what I'm willing to do. Will testify pursuant to the state subpoena, so I can get all the immunities that we talked about. But after that, I want to be able to put on the record that I intend to invoke my Fifth Amendment, and I'm entitled to use immunity, and I want that to apply to cross-examination, and I'm not going to come on behalf of my mother, Donna. Not going to do that. And so Donna's team will get to cross-examine Wendi. They're going to get to ask her questions, but only about the topics raised by the state. So they had a problem with that. It won't surprise you to hear. And what I want to do is show you a little clip from today's hearing. So here's what happened. The hearing involved two issues. One, they took under seal. They went back in the back. We got nothing on that. But the other one, we actually did get to hear Donna's team argue why Wendi should be forced to testify under their subpoena. And here's what they said.
Be other issues where she could testify to something that she's not taking a chance, if you will, that she's going to say something that could be used against her in the future. There could be other matters that are raised in the trial that we simply want to get testimony from her as. She is the daughter of our client.
So what she's saying, I think, is correct in general. She's saying, Wendi, not every single word out of Wendi's mouth might incriminate her. She may have things that she could say that are really important and relevant to Donna, but that have nothing to do with incriminating Wendi. And you should allow that. Now, Wendi's lawyer argues against it.
It was addressed by Judge Wheeler in the second Mabanoa trial. It was also decided upon by the first DCA in July 2025, when the DCA ruled that the procedure used by Judge Wheeler was entirely correct, and the subpoena in that case was quashed. I indicated to the court then, as I will now, that Ms. Adelson will assert her Fifth Amendment rights with respect to any relevant question asked by the defense. So the only result of the defense procedure would be to have the client's daughter take the stand and invoke the Fifth Amendment in front of the jury. And that the court decided by Judge Wheeler that that would be inappropriate. And we would ask the court now to follow the same procedure as Judge Wheeler and follow the same procedure that was upheld by the first DCA just 1 month ago.
Your Honor, in fact.
So let me stop there and just explain a little bit, because it's not so easy to hear some of the witnesses. The judge, however, you'll be happy to know, is a lot clearer than the last hearing. So in this one, what Wendi's team is saying is, look, this is a done deal. This has already gone up on appeal. The appellate court has decided it, not just in a similar case, in this case. They've decided Wendi doesn't have to take the stand and invoke the Fifth Amendment, that she can look first. She can testify for the state under immunity, and that's where she can stop. She'll have to answer cross-examination questions on that, but that's it. And you, judge, should do exactly what the other judge did in Katie's case. You should allow this. Now, Wendi's lawyer gets up and makes a very good argument, I think. Let me go add one more thing about what Wendi's lawyer said. So Wendi's lawyer said, one of two things is true, Judge. Either this is going to be not relevant at all, in which case, why are they asking Wendi about it? Because it's not relevant. Because Wendi's lawyer is saying if it has anything to do with this case and it wasn't raised by the state, I'm going to object. I'm going to tell her to take the Fifth Amendment, and that shouldn't be happening in front of the jury. That shouldn't be something you allow. So here's the final argument made by Donna's team.
Actually, we're in a vastly different circumstance. Our client certainly has information, knows information about her daughter that Ms. McBanow would not have ever been able to know. It's our position that it's premature.
So I personally do agree with them. I'll talk about that in just a minute. But here's what the judge said. The judge seemed to think, well, this is really going to be kind of impossible. What am I going to do? Ask question by question exactly what each time, like Wendi, well, you'll hear him. I'll let you hear him say it.
Expectation is for me to ask the question. She will make some sort of signal. I'm invoking the juries to be removed, and then we do this for the entire defense direct.
No,
he's laughing like, how's that going to work?
That if we get into this posture, and absolutely cross-examination may be sufficient, but if we get into the posture of needing additional, I would suggest that potentially proffering the questions, and then she and her counsel can advise the court if she intends to invoke her privilege.
Having reviewed the applicable authority on this issue and also reviewed the prior transcripts on this matter that were also ruled on by Judge Wheeler concerning this same subject, I am going to adopt a similar ruling. The defense cannot give the witness immunity as it relates to any matters in which she would testify under and could properly invoke the Fifth Amendment privilege. No witness can be called to the stand simply to invoke the Fifth Amendment, as there would be no basis for this witness to take the stand and give testimony on a relevant matter that also could not affect her ability to also endanger her own Fifth Amendment right. I am going to grant the relief that is requested. If we need to revisit this issue for any purpose where the defense believes there is a line of questioning that will not go to the Fifth Amendment privilege of the witness, we will at the appropriate time, but I do believe it is the proper ruling at this point to quash the subpoena.
So I personally think, and let me pull out so I can just talk to y'all for a minute. So I do think the court is mistaken in this ruling. And the reason I think I agree with the defense that it's premature is that what could happen is that there is some entirely legitimate, legitimate thing that Wendi could testify about that Donna's team would want to ask her, and it doesn't incriminate Wendi in any way. There's nothing about it that makes Wendi more guilty. Maybe it could be where her mother was on June 5th or, something like that, something specific that Wendi might know because she is her daughter, but that doesn't mean Wendi's guilty of anything. And I think that Donna's team is correct that there should be at least a proffer at some point where they make an offer and they tell the judge, here are some things we want to ask Wendi. Now, they didn't mention a single thing, and I do think that was a mistake. I think it would have been better to say, why, here are some examples, Judge, of what we might want to ask Wendi Adelson that will not incriminate her, but that might be something we'd ask about. They could do it even in camera, just to the judge, if they didn't want to give away the questions to the state. So I do think it's a mistake right now. The judge didn't completely close the door. The biggest problem will be that when the cross-examination and then the redirect end with Wendi Adelson, at this stage, she is free to go. She is free to walk out, walk away, go back to her home and not testify any further. The judge has quashed the subpoena from the defense. And so there's no reason she has to stick around. So it's going to be important that Donna's team make that showing if they want to have any chance of having the judge rule their way. I think it would be best for everyone involved if they do that, because what you don't want is for this to be something that's a time bomb inside the case that explodes on appeal. When the appellate court looks at this and goes, gosh, you shouldn't have released her from the subpoena until you knew whether or not there were questions that would not have incriminated her. You were entitled to know that first. So, but in any event, this has to have been extremely difficult for Donna to hear, because this isn't the approach that Wendi took at Charlie's trial. Apparently, she mentions Katie's trial as the backdrop, what she's done before, but she doesn't mention Charlie's trial. So I assume she did not ask for this in Charlie's trial. And if they were truly working together, if she and her mom were working together, it might be possible that they could arrange some kind of agreement. You can ask about these things, you can't ask about the others. Apparently, that's not being worked out. That's not a complete surprise, because we have heard on the jail call, on the jail call between Donna and Charlie, we heard a little bit of an excerpt when there was a hang up, supposedly, Donna thought, but there wasn't really a hang up. Charlie was cut off, but the jail call kept recording, and they recorded Donna talking to her friend in the room. And here's an example of some of the stuff that she said.
So, I can't get in touch with her.
She was saying she can't even get hold of Wendi.
And Rebecca, not about the case. I just got off with Charlie. He's worried about you. He wants to know what. Oh, because I said, yeah. We know you never ask anything about your brother, and she doesn't. And she told me it's because her lawyer said she shouldn't ask. But we found out it's not true. So I wrote this last night. We know you never ask anything about your brother. This is 8 o'clock last night. But we just got off the phone with him, and the first thing he asked was, how's Wendi holding up? I didn't have the heart to tell him that you never called us or asked about him. I just said, we weren't up to phone calls right now. Everyone looks to protect you. I bet you've got a lot to think about. But then she didn't answer. So then I got another call from Charlie that night, and I said, just got off the phone with Charlie. He's worried about you. He wants to know why we didn't speak. I told him a lie. I said, we're only speaking with you and Dan right now. I couldn't bear to tell them the truth. Your sister never even called us, is the truth. Dear Mom.
What might have happened then, right? And what Donna even says she thought was going to happen is that Wendi would come rushing over to the house. Oh, I'm so sorry, Mom. But that is not what happened. Instead, Wendi wrote a really snarky email back to Donna. And the words that were just said, which cut off right then, were, Dear Mom. This is the letter from Wendi, the email.
I know you are upset by the verdict, but the anger directed at me is not justified. I don't know how much anger. We don't. I'm not responsible in any way for Charlie's situation. I am not guilty because I did not do anything wrong, and I was not involved in any way with Danny's death. She was. When I was interviewed by the police and testified in court, I told the truth, as I was required to do. I cannot control how the prosecutor used my statement for Charlie's trial. Again, I didn't say that. Also, as you know, my lawyer has advised me not to talk to my family or anyone else about this case. Now, about the case, which is true, we've never done it. I followed his advice despite your disagreements with this guidance. Please do not text me about this case anymore. Not about the case, is it? Not what I said. About her brother, and that he wants, how are you, Wendi? How's my sister holding up? Mm-hmm. Yeah. If you have anything
Donna has a point here
about the case, please go through our lawyers. Right now, I have to be singularly focused on taking care of the boys during this difficult time. So I wrote back, okay, we have no desire to speak with you about the case. I guess Dad and I are just shocked that you didn't think of coming to see us or even calling us. We are your parents. We are and have always been there for you and the boys. None of what we wrote matters about the case. That's over. I just want you to know how many times Charlie is asking about you. Not only do you not ask about us, but not one question about Charlie, right? We will need to give you some information.
So let me stop there and just say, I think Donna has a point, really. It is kind of shocking that Wendi wouldn't have called her parents to at least talk about what happened. Like, I'm so upset. But Wendi clearly is extremely worried about prosecution. She is trying very hard to cut herself off from family members so that she doesn't end up embroiled in this any further than she already is. So Donna tries telling her things like, oh, well, it has nothing to do with the case. I really want business assistance, she says. Here you go.
Shortly. And we need some business assistance. I want her to have all these papers and the wills. I want her to see all this. The other thing is the visa, which she would know about. No, I said we need some business assistance. If you can't do it, we must find someone who can. I hope you understand that it has nothing to do with the case. There is no more case. And the other thing I don't understand, how my daughter could help me with this, we've been looking it up over and over, because things change. If there is extradition from Vietnam, maybe she knows about. Maybe she can look up the extradition issue before we waste our time.
So, of course, Wendi was an attorney. So Donna is saying, well, maybe Wendi has some information that would help us. Of course, I'm sure Wendi is very happy that she was in no way involved in the attempted flight to Vietnam, which Donna had searched non-extradition countries beforehand. So Donna has a friend with her, as I said, in the room while she's talking to Charlie. And this friend asked a couple of times, well, okay, if you tell Wendi you're leaving, I mean, is she going to tell on you? Is she going to go to authorities and say, my mom is about to leave the country? Are you sure you can trust her, basically? And I think Donna is thinking to herself that this may be the last time she ever sees Wendi. Maybe. She's leaving the country, I think, not planning to come back. She may argue differently. She had a one-way ticket to Vietnam, which she had researched as being a non-extradition country. And she wants Wendi to come over. She wants her there.
I would like her to come up here so she could see it. I don't think that's asking too much. She can live 3 hours away. Every time she says, can you do this? Can you come here? Can you do this? Everything. How many times do we have plans that I really can't and have to cancel? Wendi needs us for this. Wendi needs us to babysit. So we've been really good nannies, and I guess our job is up. Because now the boys are older, they can go out with friends, they can do things on their own. So she doesn't need grandma and grandpa. Okay, pretty hurtful. I have one son that I don't speak with. I have one son who's close to being dead. And my daughter, whom I love, is doing this. I don't get it. I don't get it. I said to Harvey, I swear to God, our family was cursed. Absolutely cursed. And I don't know how to take care of it.
All right, so we'll pull that out. So clearly, there's no question about it. Donna is extremely upset about where her relationship with Wendi is. And this was before Donna was even arrested. Now you see Wendi coming in, not willing to work with or help Donna's side, focused on the possible problems for her created if she has to testify against herself. By the way, I'm not blaming Wendi for this. If I were her lawyer, I'd be telling her the exact same thing. Absolutely not. We should do whatever we can to keep you from testifying in this case. I just want you to see kind of where things stand. That is the first daughter. And that was the first motion that was discussed today. Like I say, there was another motion that got discussed today, but it wasn't discussed on camera. We don't know exactly what was said. We have been hearing about this investigation the state is doing, about this completely different matter. It's all been hush-hush. There's been discussion here and there about who exactly was involved. It involved other inmates. There was a hint, a rumor that maybe it had to do, not a rumor, but hint through some of the things that happened in court or in documents, that it had to do with testimony, with Donna trying to get people in jail to testify on her behalf, but the state believed falsely. But so little information about it. And finally, a little bit of information is leaking out. And it involves a woman who says Donna called her jail daughter. We're going to get into all of this. Let me say a few thank yous. Megan, I'm glad you were looking forward to tonight. I'm so glad the show tonight. Rodeo Gal, thank you very much for your super sticker. Sore Throat is wondering about why she is so hell-bent on this immunity. The truth is, Sore Throat, I think most lawyers would tell her, it doesn't matter what you think about your guilt or innocence. The fact is you don't want the state using any of this because they may think you're guilty even if you're not. So that's what I think her attorney is probably telling her. Obviously, there's a reason why it's best not to have to invoke the Fifth Amendment, because just like you're thinking, a lot of people will think that. Sore Throat will think, yeah, I don't understand why she is invoking the Fifth Amendment if she, in fact, had nothing to do with anything. Janet, for 18 months. Thank you. A year and a half of fun. Thank you, Janet. I appreciate your being a member for that long. Thank you very much. And Trisha, thank you very much for your super chat. Okay, we'll stop right there. And I want to move over to talking about daughter number 2. This was a friend, apparently, that Donna, a so-called friend that Donna made in prison. It's someone Donna trusted so much that, according to this witness, she called her jail daughter. But in exchange for a lighter sentence for herself, the woman has now turned jailhouse informant. She is betraying Donna to get a reduced sentence for herself. Now, we do not know, like I say, all the details. It gets pretty deep and pretty convoluted, but here's what I would describe it as like this. Like, if you're in a room and a strobe light flashes once, you're going to spot something, maybe the door over here, but you may not see the table over there. I mean, you're going to get a quick impression, but it was one quick flash of light and you just got what you could see out of it. So here's what I think they're headed towards is, I think it has to do with Katie Medbanwa. She was Charlie's girlfriend. She was the one, according to the state, who hired the hitmen. Now, we covered testimony in detail last week in one of my shows. It was a mess, an unmitigated mess, because she testified twice in her own trial saying, yeah, I absolutely was being paid by the Adelsons' dental practice, but that's because I was working for them and I never hired hitmen and I certainly was never paid money. I mean, just on and on. She insisted she had nothing to do with this. She was not involved. Then she gave interviews as she was trying to get a reduced sentence because she was sentenced to life plus 30 years in prison. So she was trying to get that reduced sentence, and she came to the state and she made 2 proffers where she said kind of a hybrid thing, like, well, I did this, but not that, and a little bit of here, a little bit of there. And then finally she came to trial and she said, yeah, okay, I never worked for the Adelson Institute. They were paying me for this, and I was the conduit to the hitmen. But even then, it was really a mess. You've got to go back and see that video because it's really going to be difficult for her to testify. And I asked the question, should the state bring her or not? There were questions. Not everyone was sure on that on our vote that we did. But anyway, so what I think this is about is that Donna was going to put witnesses on who supposedly had met Katie in jail, and they were going to testify that Katie Medbanwa something. I'm thinking maybe that she admitted she was lying when she said Donna and Charlie were involved, that she really just wanted to get a good deal. But since we don't have the details on this, I can't say for sure. And that's just a guess, just my vague impression without any real meat to back it up. We'll see if this comes out at trial, what happens. So, but this witness, the jail daughter, is going to come in instead and say that Donna was trying to stir up this story, whatever it was. And that's what the state was investigating. They were investigating the state trying to stir up fake witnesses. So I'm going to show you the motion in just a minute, but I decided it would be a little easier to give you a timeline of what exactly is kind of said in this motion, because this is going to be super important as we move into the trial. It's going to be important because we are going to be looking at whether or not this is a piece of brand new evidence that the state will have against Donna Adelson. So back in August of 2024, Donna Adelson was moved to the annex. And sometime about a month later, this woman named Drina Bernhardt was arrested for a violation of her probation and a new charge. Somewhere in there, apparently, Drina Bernhardt was moved into the same area where Donna was. There wasn't a date on that in the motion. But Drina Bernhardt, in December 5th, was interviewed by a detective, Joshua Turner of the Leon County Sheriff's Office. Now, at no point does it say that had anything to do with this case. But after that first interview, Bernhardt wrote a letter to the detective. And that appeared to really start things moving. So it must, I'm guessing that that letter included something about Donna Adelson. Then on the 18th, Turner interviewed her again. And Drina Bernhardt gave him information about two cases, a human trafficking case and Donna Adelson's case. And from here on, we're going to hear what was said about Donna Adelson's case. Now, where am I getting this information? I'm getting it from the brief filed by the defense. There isn't a response filed by the state, so I can't give their position. This is all argument by the defense. Is it true? Correct? I have no way of knowing. I am telling you what the argument made to the court is. So on the 20th, just 2 days after that one interview, they take Drina Bernhardt to the state attorney's office to interview her again. And she tells them, Adelson called me her, quote, jail daughter. And the investigator, Jason Newland, who will testify at trial, who did testify at Charlie's trial, warned her, so you cannot be an agent for us. I can't send you in there to ask her any questions. Listen, if she has a casual conversation with you, there's nothing stopping you from having a conversation with her. Don't make things weird. Don't initiate any of these conversations. And this is one of the biggest things that is to come out of this meeting. He's telling her again and again, listen to me. Don't make it awkward, but definitely do not go back in there on our behalf thinking you need to get more information. And we will talk about why he's telling her that over and over again in just a minute. So the state keeps interviewing Bernhardt. We aren't told what any of those interviews say. The most we got was with that one on the 20th. Then Bernhardt, in this period of time, we don't know exact dates, also provided written documents to Detective Turner of what Donna Adelson had asked or instructed, it should say instructed, Bernhardt to say 10 times or more. So multiple times, apparently, she provided written documents where Donna was asking her to say something. I assume those would be maybe her notes. Then on April 7th, this is just, I think I have 2024. That should be 2025 probably. The state disclosed these two jailhouse informants to Donna Adelson. Drina and an unnamed second person, we don't know who that is. Bernhardt can't be located because she has violated her probation and pretrial release conditions. So she's finally arrested, and this is just 2 weeks ago. On August 5th of this year, she's arrested. Right away, Donna Adelson goes in and deposes Bernhardt. And Bernhardt says, I didn't ask Donna Adelson any questions. Then later says, I did ask Donna Adelson questions, apparently in the course of one deposition. That's what the defense argues. Same day, investigator Jason Newland and special agent Patrick Sanford interview another inmate. This one, Mickey Easterwood. She was incarcerated with both Donna Adelson and with Bernhardt, Drina Bernhardt, and says, and according to this witness, this jailhouse informant, it was very obvious that Drina Bernhardt was trying to get information out of Donna. So the state then tells Donna Adelson's team about Mickey Easterwood. And Easterwood says, yeah, Bernhardt didn't just ask Adelson, didn't just let Adelson talk and then write it down. No, she specifically asked questions. she tried to get her to say things. She didn't just listen passively to what was being said by Donna. And so there was some kind of deal made, and we're told that she had been offered 5 to 6 years. She could have been facing many more years than that because she was a prison releasee re-offender, but instead her probation was reinstated even though she had violated it. So she was given some kind of special favor for that. Okay, let's head over to the motion that was filed. So I thought it'd be easier to do all of that in terms of a timeline. Here is a discussion of the law, and we're just going to do a few sentences from here. So the Supreme Court, and they cite the case, held that law enforcement cannot deliberately elicit conversation with the defendant in order to elicit incriminating information. The Sixth Amendment prohibits law enforcement officers from deliberately eliciting statements from a defendant after the right to counsel has attached. So the reason that the detective was warning her so sternly about don't go in and ask questions is they knew it would disqualify her being able to testify about what Donna had said. If she, acting on behalf of the state, is pushing, give me more, and going in actively trying to get this, then they can't use her statements. And that's why this new witness, Easterwood, is so important. Is that one more sentence, I think. By further allowing Bernhardt to benefit from her continued conversations with Adelson, her probation was reinstated instead of the 15-year prison releasee reoffender sentence or the purported 5 to 6 year offer. The state incentivized Bernhardt's continued actions on the state's behalf. All right, so let's pull that out and we can talk a little bit more about this. So here's what we know now, and not every detail, but we know that this person who was very close to Donna while they were in jail together, that Drina Bernhardt was going to come in and say something about what Donna was talking about and asking for, something having to do with the testimony of witnesses. But we don't know any details about it. What we do know is that there is serious question about whether or not that will come into trial now because of the fact that this new witness is saying that it was not just a acceptance of information which was then passed through to law enforcement, but that after law enforcement contacted her and incentivized her, she then actively pushed to get this information, and that's not going to be allowed. We don't have the state's response. I wish we did, and I could give you a little bit more about what their argument is. But as I say, everything went into a private in-camera conference with the judge at that point. So that was not released publicly, and we don't know for sure what was argued by the state or how the judge ruled, or at least last I checked the docket, there was not yet a ruling from the judge on what exactly he was going to be saying or doing. All right, so that is not one, but two daughters who are going to be or want to offer, have what Donna has to be perceiving as stabbed her in the back. She just has to be seeing that she had this great relationship with Wendi, and now Wendi won't step up for her. Wendi won't do things for her. And now she had this friend so close. She called her jail daughter. And now this person is testifying against her, actively was all alone writing down everything she said, giving it to law enforcement in order to make sure Donna was convicted and to get a benefit for herself. Really, really a lot of drama coming out right before trial. Obviously, we'll have to wait and see what ends up coming in at trial, what exactly gets asked. Let me let's do some questions. If you would put your question marks at the beginning, I can spot them a little more easily, but let me go through over here. Jackie P has been a member for 18 months. Thank you, Jackie P. I really appreciate that. And Jackie P, a phenomenal, gifter of Lawyerly memberships, has gifted 5 more. If you aren't a member yet, be sure to turn on your ability to receive a gifted membership. Our mods will put that into the chat. Speaking of which, many, many thanks to Marlon and Mama Pinks, our mods here on the channel. And thank you, Jackie P. I appreciate it. If you're not a member, you can always click the join button next to the Lawyer Lee name right below this video. If you're on your iPhone, you'll have to go in through the browser or use your computer instead. Yes, Mildred is should have Mildred. They should have asked you for this advice beforehand, but that's exactly right. Dear incarcerated Adelsons, there are no friends in jail. Maybe after you're already convicted, maybe then it doesn't really matter, but definitely everyone's looking for the advantage. So you're absolutely right, Mildred. Denise Smith, new member, fantastic. Thank you, Denise. Glad to have you. Gropo, thank you for the super chat. Much appreciated. And Idiot Wind is asking a question. Even if each question is preferred to Wendi's counsel beforehand, the state gets to cross anything it says, and that's not shielded by immunity. No. So I think the answer is it would go a little bit differently. Idiot Wind, the state is going to put Wendi on the stand. So the state will have Wendi on direct examination. Then the defense will get to cross-examine Wendi. And then the state will go again with a rebuttal questions. What's not going to get to happen is that during the defense case, they bring Wendi back in and ask her a series of questions that weren't relevant to what the state asked, but were things that Donna wants in, things that would help Donna in her case. And then the state would cross-examine it, and then Donna would get a chance to go again. So what's not going to happen is 2 cycles like that, at least under the court's present ruling. If they end up with some good argument, maybe the judge will allow them to ask a specific set of questions or something like that. So, but it is true that, and I think this is what you were asking me. It is true that Wendi is going to get to cross-examine after the state goes, after the state asks Wendi questions. But it doesn't always cover all the things you want. So that's why both sides have subpoenaed Wendi. The state might want to cover 10 topics that help the state. And on every one of those, Donna will be allowed to cross-examine Wendi. But what if Donna also had 10 topics she wanted to ask Wendi about, but the state didn't ask about those? Well, Donna can't just cross-examine on anything that wasn't part of what the state brought up. The cross-examination has to be limited to the topics brought up by the state. So hopefully that helped. Hey, Sore Throat is a new member. Welcome. Glad to have you. All right, let's take a look at where the questions are. I'm going to back up a little bit. I see I missed several. I do like it when you put them in red. That makes it a little easier for me. All right, let's see how far back. Okay, I think, yeah, I'll stop right there. I may or may not be back at the beginning. Okay. Lorna Lee asked me, if a witness on the stand is asking to make an incriminating statement, does their lawyer stand up to stop this and advise to invoke the Fifth? That can happen. Yes, that can happen. And so that is what the judge was trying to figure out, is what exactly would be the process that you expect would happen here? Do you want each time Wendi kind of has to make this judgment call on her own and give me the high sign like, oh, judge, this is one of the ones we talked about? And then okay, we dismiss the jury, we have argument, and then we bring the jury. I mean, how is that going to work? Or maybe I'll bring you up I bring all the lawyers up and we argue about it. And then, while the jury's sitting there. But either way, how is this really going to practically speaking work? But yes, there could be a question where the witness is asked to invoke the Fifth. Usually, just to be on the safe side, the lawyer will tell the person, invoke the Fifth to everything. So I don't know exactly what the process. The judge didn't know exactly how he would do that. And he asked, how exactly would we handle that? He asked that very question. Brianna wants to know if I handled Ted Bundy's appeal on the 11th Circuit of Appeals. I would not have. I wasn't our death penalty clerk, which I am so relieved to say. It was a brutal job. I was a clerk on the 11th Circuit, but not, I did not do the death penalty work. I would say too, I can't really talk about specific cases that I worked on, but I can state blanketly I was not our death penalty clerk, so I can say that much. Okay. Freddie's cat. How can Donna discredit the jailhouse snitch or daughter? Well, she's got one effective way right now. I have no idea how the Easterwood woman, Mickey Easterwood Lane, how she got connected with the detectives, but they interviewed her and she said, yeah, this woman made this up, or not really made this up. This woman pressed for it, and therefore it should not be allowed. It would mean that it would not be allowed. So that's one way she might get it dropped entirely because of the coercive nature, that it was the state actually going in and pushing for a person represented by counsel to make statements to them through a roundabout way, through one of the inmates. So that may be one way. As far as discrediting her, I don't know. I don't know enough of the facts about what she's going to say. Lots of mystery surrounding that whole issue. Will it come in? How much of it will come in? And what is it all about? Lots and lots of mystery. Bonbon, do you think authorities are watching Wendi to see if she might leave the country? And I do think they probably are watching that. They probably have some kind of, I assume they can maybe do some kind of search if someone tries to board a plane. I don't know. That's Florida. It's not the federal government, but maybe they're able to get some kind of agreement with a local agent. I mean, with a federal agency to allow them to do that. Why would I don't know whether Donna is a Tom Petty fan, Helen Beatty. Let's see. Okay, looking for question marks here. Let's see. I need to go back over here. Okay. Rodeo Gal, any thoughts as to what Robert will be questioned on? Not for sure. He apparently did make the statement that he believed Donna was guilty, that he believed she and Charlie were maybe Wendi. I don't know. But in his deposition made some statements about what he thought about their guilt. I don't think that should come in trial. I assume other things like, for example, how much Donna wanted their Wendi's family to move down there, or how upset she was with Dan Markel, because what we heard from Charlie was, yeah, Donna it wasn't that big a deal. And Wendi said too, yeah, nobody really thought Dan was going to get away with it. Remember Wendi said something about how her mother had made cornbread or something for Dan Markel. And so it was all fine, even though Dan had filed this motion. He didn't really mean it. They were just having a fight in court. He loved her mom. And so maybe Robert Adelson will say something contrary to that, maybe that kind of testimony. When does jury selection start? R1133 Rocco asks. Tomorrow. Tomorrow is the day when it begins. It'll take a little bit, but there could be opening statements Thursday, Friday, who knows, maybe Wednesday. We will be going and covering the trial every day. We will be doing live. I will be here doing legal analysis and commentary. Please join us for that. I have never done this before, but I'm really excited about it. I think it'll be really interesting. And I would love to have you join us, and we'll sit and watch the trial together, and I'll talk about what I see happening, and we can just go over it together. All right. When does the trial start? Yes, tomorrow, if you count jury selection, but opening statements. The judges said it's going to be pretty quick. As soon as the jury gets selected, a little bit of a break and move right into opening statements. The question, of course, is how long is it going to take? It's really hard to know how long jury selection is going to take. Remember, Donna's team asked for a change of venue. They wanted this out of Tallahassee. They wanted it moved somewhere else. They don't think Donna can get a fair trial there. They said it's impossible to let a jury that doesn't know far too much about this case and already have a lot of preconceived notions about Donna. So that is still up in the air, in that the judge has denied it, but said, we can, if we have a problem, we can revisit it at the jury selection stage. We'll see. Maybe there will be something. I'm sure there will be another motion raised about it. But if the judge has seated all the jurors, I think there's zero chance by then, unless they just literally can't get enough, which I don't think will be the case. How does the prosecution or police protect against Donna paying a juror to hang the jury? I think the best way that the state does that is by having laws that would mean not just Donna would be criminally charged with that, but also the person receiving the bribe from the jury could be criminally charged for accepting that. So by making both sides illegal, there would still be criminal consequences. So even if Donna hung the jury, if anyone ever found out, both of them could be criminally charged for doing that. And then on top of that, if Donna had actually done that and they found out about it, they're just going to try her again, even if it was a hung jury. So in the end, and you add to that the fact that it's not really all that easy to do. I know that in movies, they make it seem like, oh, well, maybe it's very possible to do. Lincoln Lawyer is a great example of that. Love the show Lincoln Lawyer, by the way. Dad and I cannot wait for the next season of Lincoln Lawyer. We chat periodically to see when will that come out. Speaking of which, thank you so much for your nice messages about Dad. He came home from the hospital today, and so he is definitely feeling better, and I'm glad to have him back here, back in home environment. So thank you all for your really nice messages. I really appreciated that very much. Cocoa Latte Sunshine is a new member. Well, welcome. We are glad to have you join us, Cocoa Latte. All right, we'll do one last question. Oh, I see Q's at the beginning. Is there any case law beyond the appeals court ruling on the Fifth versus Sixth Amendment rights? Has this ever been ruled by the Supreme Court? I don't know the answer to that. I haven't researched it myself. This is from Sadiq. Great question. I assume that they would have, if there were a U.S. Supreme Court opinion on it, that they would have cited that. And the fact that they cited other cases suggests to me, so I don't know I don't know. There's the bottom line. I don't know. Great question. I don't know the answer. Haven't researched it personally. Susan, why does Wendi need all these immunities if she and her family have this crime? And Susan, a lot of people will ask that very question. And it's one of the reasons why taking the Fifth Amendment, no matter what the jury is told, makes everyone wonder, wasn't there some guilt here? And so I think that lawyers typically tell their clients, you need to do this because things can be used against you in ways you don't expect, even if you think you're innocent. So I believe that would be why. I believe her lawyers will be telling her that. Dalai Lama asked whether the state can bring up the fact that he was convicted of Dan Markel's murder, and they can and will bring that up if he gets on the stand and if he testifies. What can the state say or not say about this conviction? Well, they can talk and they can ask a question, just like you put it, about whether or not the conviction has occurred. All right. Well, we will be live again probably Wednesday night at 7 p.m. We normally go Monday, Wednesday, Friday at 7 p.m. Eastern. But as soon as opening statements kick in, we will be live for the duration of the trial. So please join us. We are going to really enjoy that, I think, and we are looking forward to seeing you there. Let's see. Somehow, nope. What I'm trying to do, in case you're wondering, what is she saying? I am trying to figure out how to play the outro for you. Remember, I told you I was like adjusting everything, trying to figure out how we can do it for purposes of the live stream for the trial. And I figured out some way to put in the outro here over to the side. However, it's not playing. So let's see. Is there any other thing I could do? Oh, nope.